the topic that I want to cover today, as the initial topic before I do live Q&A, has to do with communication. Along the lines of negotiation. So you'll want to think about this information whenever you're, at the point in your case when you're negotiating, trying to settle it, trying to, maybe your attorney's working with their attorney, or if you're pro se, you're working with them, or you're working with their attorney. And it's just three things that I want to share with you guys that I have used over my nearly 20-year career as a custody attorney, and from some of the things that I've seen actually on the bench too, when I would be in settlement conferences and stuff like that. So basically, what it is, there's three things, okay? Three, I guess, musts, you would say, whenever you're negotiating. And the first one is, and I think everybody probably knows this, it's kind of like negotiating 101, but it's, to start a little higher than what you're willing to settle for, okay? And the reason why you want to do that in a custody case in particular is because flexibility and concessions, which concessions kind of show the judge that you're being a little more flexible, but concessions and flexibility are, can usually be a positive in these kinds of cases, because the judge in a lot of jurisdictions will be looking for the party, this is generally speaking, not in all cases, but generally speaking, they'll be looking for the party that is, more willing to work with the other side, more encouraging of a relationship with the other side, with the children, things like that. So it's always good to start a little higher than what you want to accomplish. So or what you're willing to settle for, I guess I should say, in these cases. So if you want, and I'm literally just making up this example off the top of my head, but say that you wanted like every other weekend, Friday to Sunday, and then like an overnight during the week or something like that. I don't know. Say that's what you wanted. Well, what you would do is you would request like maybe every other Thursday to Sunday, or every other Friday to Monday, and then maybe one or two, maybe two nights during the week. Okay. So that's number one. Start a little bit higher than what you're willing to settle for. All right. Number two is don't negotiate against yourself. And what I mean when I say don't negotiate against yourself, if you go forward with an offer and, there's basically two things you can do to avoid negotiating against yourself. Number one, if you make an offer, like I just said, say you make an offer for what you want, regardless of what changes during that. So if, they bring up an argument to you or to your attorney or whatever, or they bring up some information, don't back off of that. Okay. Don't negotiate with yourself. So don't, if in that example, if you were saying, I want every Thursday to Sunday night and two nights during the week, and they come back and say like, well, my work schedule is difficult, or, anything at all to kind of try to make you rethink that proposal, don't immediately come down to something lower. Okay. That's called negotiating against yourself. Okay. You'd want to hold strong on that until they came back with a counter offer. Right. And I said there were two ways you can negotiate against yourself. The other way that you can negotiate against yourself is if they come back with a counter offer, and then you automatically jump into splitting the difference and come down and really make concessions. Okay. You don't always want to do that either, because you want them, you're trying to get them to come up to you. You know what I mean? You know what I'm saying? So you would maybe just shave a little bit off to get a little bit lower to them. Okay. The one thing that you need to be careful about whenever you're doing that method is if you're in the courtroom and doing that method, you want to maybe back off that a little bit more, because again, typically a judge likes to see someone that's trying to be flexible and encourage in a relationship and stuff like that. Okay. And then the final thing, the third thing that you want to do whenever you're negotiating, and this is something that I've done in all areas of the law that I've practiced, in particular family court and criminal court, when I was doing a lot of criminal trials on the defense side. And that is, whenever you are asking for something, you absolutely need to tie it to a logical, factual piece of evidence that's in the case. Okay. Here's what I mean by that. Instead of just going back and forth and like you making your offer, them making their offer, you lowering yours, them upping theirs until you try to get in the middle, use precisely why. So maybe it's your work schedule or their work schedule that should enable you to have a specific days of the week or specific days of the weekend. Okay. Maybe they get home like 10 p.m. from work on the Friday night or something. And instead of uh, you taking them later, you could take them earlier. And the reason that you would say it would be because, well, you're going to be at work, or, they're at work every Friday until 10 p.m. anyway. So I want to get them in earlier. So then they're not like going to be with someone else. They can be with me, stuff like that. Or like logistics regarding school and, transportation to school. Or exchange logistics and maybe lessening the exchanges, something like that. Whatever you do though, tie it to, and you can, like, what I would advise all of you guys to do is think through the details of your case and the schedule of your case, and think of all those surrounding details like work schedules, distances between each other, distances between work and home, between your work and their home, or your work and their work, whatever, the exchanges, who you guys have to help out with, like babysitting or child sitting or whatever, or transportation. Think of all of those details. And even if it's not maybe 100% necessarily the truth, tie it to one of those. No, I'm not saying it's a lie, but I'm saying if it's not, I shouldn't say if it's not the truth, if it's not the actual reason that you want that schedule, right? It might not be the actual reason, but use that logistical reason when you're negotiating. And then you can also bring it up in court. It might be something totally different. It might be because, you just want more time, or, you want them to have less time or something like that. That doesn't mean anything. Like, your desire to have more time is not going to be nearly as powerful and persuasive as something logical and factual in the case. Okay. So even if it's not necessarily your sole reason or a reason at all for making an ask, come up with something that is factual and logical, that will make sense, that you can have, the other side's attorney or the mediator or the judge think, well, that makes sense. Like that. What's wrong with that? That makes sense. Think of being able to pitch it in a way like that. Okay. And so those are the three things that you want to use with negotiation. It's a communication pillar.